I opened my front door on that February morning in Boulder, Colorado, expecting another peaceful weekend, but instead found a neon orange violation notice slapped across my doorframe like some kind of scarlet letter for homeowners. The notice cited my property for excessive snow accumulation on my roof and threatened a $500 fine if I didn't remedy the situation within 48 hours. I stood there in my bathrobe, coffee mug in hand, staring at the paper as snow continued to fall around me in fat, lazy flakes. My name is Owen Ortiz, and I had lived in the Meadowbrook Heights development for 3 years without any serious problems with the homeowners association. Sure, they had sent me a passive-aggressive note about my mailbox being the wrong shade of black once, but nothing like this. I looked up at my roof. Yes, there was snow on it. A lot of snow, actually. We had gotten nearly 4 feet in the past 2 weeks, and the drifts on my roof had built up into impressive formations that probably looked dramatic from the street. But my house was a 1980s ranch-style build with a solid structure. I had never worried about snow load before. The fine print on the notice referenced Section 14.7 of the HOA bylaws, something about maintaining property aesthetics and preventing hazards to neighboring properties. I crumpled the paper slightly in my fist, feeling my blood pressure rise. This was absurd. Half the houses on my street had similar snow accumulation. Why was I being singled out? I went inside and called my neighbor, Tom, who had lived in the development for over a decade. He picked up on the third ring, sounding groggy. "Owen, it's barely 8 in the morning on a Saturday. Did you get a violation notice about snow on your roof?" "What? No, why would I?" "Because I just got one threatening me with a $500 fine if I don't remove the snow within 2 days. There was a pause. "That's ridiculous. Your roof doesn't look any different than mine." "I know. Who's even on the HOA board right now?" Tom sighed. "Still Patricia Pemberton as president. She's been getting more aggressive lately. Last month she tried to fine the Johnsons for having their trash cans visible from the street, even though it was literally trash day." Patricia, of course. I had met her exactly once at a neighborhood barbecue 2 summers ago, and she had spent 20 minutes lecturing me about proper lawn watering techniques, while I tried to escape to get another burger. She was the textbook definition of a busybody, probably in her early 50s, with that precise haircut that seemed to be standard issue for women who enjoyed wielding petty power over others. "What should I do?" I asked. "You could comply, but honestly, removing that much snow from your roof could be dangerous and expensive. Those services aren't cheap, especially right now when everyone needs it. So I should just ignore it." "No, they'll actually enforce the fine. Document everything, maybe get a professional opinion. Fight it properly." After hanging up with Tom, I spent the next hour researching snow removal services in Boulder. Tom was right about the cost. Every company I called quoted between $800 and $1,200, and most were booked out for at least a week anyway. One company could squeeze me in Monday afternoon for $950, which was almost twice the cost of the fine itself. I sat at my kitchen table, laptop open, reviewing the HOA bylaws I had signed when I purchased the house. The document was 73 pages of dense legal language, most of which I had skimmed at best during closing. Section 14.7 did indeed mention property maintenance, but the language was vague. It talked about preventing hazardous conditions and maintaining community aesthetic standards, but nothing specifically about snow removal or acceptable snow depths. The phone rang. Unknown number, local area code. "Hello, Mr. Ortiz. This is Patricia Pemberton, president of the Meadowbrook Heights Homeowners Association. Her voice was sharp and nasal, with that particular tone that suggested she was already annoyed before the conversation even started. "I received your violation notice," I said, keeping my voice level. "Good. I wanted to personally follow up to ensure you understand the seriousness of this matter. The snow accumulation on your roof is excessive and presents both an aesthetic problem and a potential liability issue." "An aesthetic problem? It's snow. It's winter in Colorado." "The amount on your roof is beyond what is reasonable, Mr. Ortiz. Several neighbors have complained." "Which neighbors?" "That information is confidential. The point is that you need to address this immediately." "The 48-hour deadline stands." I took a deep breath. "I've contacted snow removal services. The earliest anyone can come is Monday, and it will cost nearly $1,000. That's more than the fine itself, and the timeline you've given me makes it almost impossible to comply." "That sounds like a personal problem, Mr. Ortiz. The HOA's responsibility is to maintain community standards. If you cannot comply, the fine will be assessed, and if you refuse to pay, we can place a lien on your property." The casual way she threatened my property made my jaw clench. "Don't you think this is a bit extreme? Have you sent similar notices to other homes with snow accumulation?" "I don't appreciate your tone, Mr. Ortiz. This conversation is over. You have your notice and your deadline. Good day." She hung up before I could respond. I spent the rest of Saturday fuming and researching. I learned that HOA liens were indeed real and enforceable in Colorado. If I didn't pay fines, they could potentially foreclose on my house, though that typically required significant unpaid amounts accumulating over time. Still, the threat was real enough to take seriously. Sunday morning, I drove around the neighborhood documenting other houses. I took photos of at least 15 properties with comparable or greater snow accumulation on their roofs. Some of the drifts were truly impressive, probably 5 or 6 feet high. My accumulation was significant but definitely not the worst on the block. When I got home, I found another notice on my door. This one was a reminder about the Monday deadline, with an additional note that if I attempted to remove the snow myself without proper licensing and insurance, I could face additional fines for unauthorized property modifications presenting community risk. This was insane. I couldn't win. If I didn't remove the snow, I got fined. If I removed it myself, I got fined. Professional services were booked up and expensive, and even if I paid for Monday's appointment, it might not meet Patricia's arbitrary standards. I called my friend Marcus, who worked in construction and knew about building codes. He came over Sunday afternoon and we stood in my driveway, looking up at my roof. "Honestly, Owen, I wouldn't touch it," Marcus said, shaking his head. "That snow has been there for weeks. It's compacted and frozen now. If you try to remove it aggressively, you could damage your shingles, your flashing, even the underlying structure if you're not careful." "So what do I do?" "Get a structural engineer to assess it. If they say the load is within safe parameters, you have documentation that there's no hazard. The HOA can't really argue against a licensed engineer." That made sense. I spent an hour calling around and finally found a structural engineer named Dr. Richard Chen who could come Monday morning. His assessment fee was $350, but it seemed like money well spent if it could get the HOA off my back. Dr. Chen arrived at 9 Monday morning, a slight man in his 60s wearing sensible boots and carrying a professional-looking equipment case. We shook hands and I explained the situation while he examined my house from the outside. "HOA," he said with a knowing smile. "I've done several of these assessments over the years. Snow load is a common concern, but modern homes in Colorado are built to handle significant weight." He spent the next hour taking measurements, examining my roof structure from the attic, checking load-bearing walls, and taking photos with specialized equipment. I followed him around, answering questions about when the house was built and whether I had noticed any ceiling cracks or door misalignments. Finally, we sat at my kitchen table while he reviewed his notes and did some calculations on his tablet. "Well, Mr. Ortiz, here's my professional assessment. Your house was built in 1984, which means it was constructed to meet Colorado's updated snow load requirements after the heavy winters of the 70s. Based on my measurements, the snow accumulation on your roof represents approximately 42 pounds per square foot of load. Is that bad? Not at all. Your house was built to safely handle 70 pounds per square foot, potentially more. You're well within safe parameters. However, here's the more important issue. The snow has been there long enough that it has partially melted and refrozen multiple times. It has essentially bonded to your shingles. What does that mean? Dr. Chen pulled up some photos on his tablet showing close-ups of my roof. See here. The ice layer between the snow pack and your roof surface. If you try to remove this now, especially with the aggressive scraping methods most snow removal services use, you will almost certainly damage your shingles. You might even tear them off entirely. I've seen it happen many times. So removing it could cause damage, without question. My professional recommendation is to leave it alone and let it melt naturally. We're supposed to have warmer weather coming this week. It will be gone on its own within 10 days, and your roof will be fine. Forcing removal at this point presents a much greater risk of actual damage than leaving it in place. Can you put all of this in writing? Absolutely. I'll email you a formal report within the hour. It will include photos, load calculations, and my professional recommendation. That will be $350. I paid him gladly, feeling like I finally had ammunition to fight back against Patricia's nonsense. The report arrived in my email at 11:30. It was thorough and professional, complete with engineering stamps and Dr. Chen's license information. I immediately forwarded it to the HOA's official email address. Along with a letter I drafted explaining that a licensed structural engineer had assessed my property and determined that snow removal would cause more damage than leaving it in place. I received an automated response confirming receipt. Then nothing. Tuesday came and went. I heard nothing from the HOA. I assumed that the engineer's report had settled the matter. Wednesday afternoon, however, I received a certified letter in the mail. Inside was a formal fine assessment for $500. Due within 30 days, along with an additional $50 late fee for failure to comply with remediation timeline. There was also a notice that I had 15 days to file a formal appeal with the HOA board, which would require a written submission and appearance at the next board meeting. The letter was signed by Patricia Pemberton and countersigned by 2 other board members whose names I didn't recognize. There was no mention of Dr. Chen's report at all. I immediately called the HOA's management company, an outfit called Summit Property Services that handled administrative tasks for several developments in the Boulder area. After navigating through a phone tree, I reached a bored-sounding woman named Jennifer. "I need to appeal a fine," I said. "What's the process?" "You need to submit a written appeal within 15 days of receiving the fine assessment. Include your address, the violation number, and a detailed explanation of why you're appealing. The board will review it at their next monthly meeting." "When is that?" "March 15th. "That's over 3 weeks away. The fine is due in 30 days. "Yes, sir." If the appeal is successful, any paid fines will be refunded. If you don't pay by the due date, Additional late fees will accrue at $50 per month. This is insane. I provided a structural engineer's report explaining that removing the snow would cause damage. I can't comment on specific cases, sir. I just processed the paperwork. I hung up and immediately started drafting my appeal. I spent the rest of Wednesday evening putting together a comprehensive document that included Dr. Chen's full report, photos of other houses with similar snow accumulation, and a detailed argument that the HOA's actions were arbitrary and unreasonable. Thursday morning, I printed everything and hand-delivered it to Summit Property Services office in downtown Boulder. The receptionist stamped it received and gave me a copy. I felt a small sense of accomplishment, like I was finally fighting back properly. That evening, I got a knock on my door. When I opened it, I found Patricia Pemberton standing on my front porch, wearing a puffy down jacket and an expression of supreme irritation. "Mr. Ortiz, we need to talk." I filed my appeal through the proper channels. I'm aware, but I wanted to address this directly, neighbor to neighbor. She said the word neighbor like it tasted bad. "Your refusal to comply with community standards is setting a bad precedent. If everyone decided they could just ignore HOA directives, our property values would plummet." I'm not ignoring anything. I provided a professional engineering assessment that clearly states removal would cause damage. I'm protecting my property. That report is just one person's opinion. The board has the authority to require maintenance regardless of individual assessments. "So you're saying the HOA knows better than a licensed structural engineer?" Her face flushed red. "I'm saying that community standards exist for a reason. Your property is an eyesore, Mr. Ortiz. The snow on your roof is excessive, and it makes the entire neighborhood look unkempt. It's winter in Colorado. There's snow everywhere, not like yours. You clearly haven't been maintaining your property properly, which is why the accumulation is so severe." This was getting nowhere. "Patricia, I've filed my appeal. I'll see you at the board meeting." "Fine. But the fine stands, and if you don't pay by the due date, we will move forward with collection procedures. Have a nice evening, Mr. Ortiz." She turned and walked back to her car, a pristine white SUV that probably cost more than I made in 6 months. Over the next week, the weather did indeed warm up as Dr. Chen had predicted. By the following Wednesday, nearly 2/3 of the snow on my roof had melted naturally. The remaining portion would clearly be gone within days. I took photos documenting the melting process, adding them to my evidence file. The board meeting was scheduled for 7 in the evening on March 15th, held at the community center in our development. I arrived 15 minutes early, carrying a folder with all my documentation. The community center was a bland, single-story building that mostly hosted children's birthday parties and the occasional yoga class. Inside, a folding table was set up at the front of the small meeting room, with 5 chairs behind it. About a dozen residents sat in the audience chairs, presumably there for various other HOA business. I recognized a few faces from neighborhood events, but didn't know most of them personally. Patricia sat in the center chair, with 2 women and 2 men flanking her on either side. I didn't recognize any of the other board members. Patricia wore a navy blue blazer that seemed carefully chosen to project authority. The meeting started with mundane business. They discussed the community pool maintenance schedule, approved a budget line item for landscaping, and reviewed proposals for repainting the community center. Finally, after 40 minutes of tedium, Patricia announced they would be hearing appeals. First up is the case of Owen Ortiz, property address 1723 Meadowbrook Drive. Mr. Ortiz received a violation notice for excessive snow accumulation on his roof, and has appealed the subsequent fine. I stood up. Should I come to the front? Please approach the table, Mr. Ortiz. I walked up, feeling uncomfortably like I was being called to the principal's office. The board members all looked at me with varying degrees of disinterest, except for Patricia, who looked like she had just bitten into a lemon. You have 5 minutes to present your appeal, Patricia said. I opened my folder. Thank you. As documented in my written appeal, which I submitted 3 weeks ago, I received a violation notice requiring me to remove snow from my roof within 48 hours. I immediately contacted professional services, but none could accommodate such a short timeline. More importantly, I hired a licensed structural engineer, Dr. Richard Chen, to assess the situation. I held up the report. Dr. Chen determined that the snow load on my roof was well within safe parameters for my home structure. However, he also determined that the snow had bonded to my shingles through repeated freeze-thaw cycles, and that attempting to remove it would cause significant damage to my roof. His professional recommendation was to allow natural melting. One of the male board members, a heavyset man with gray hair, spoke up. Did you get a second opinion? I relied on the expertise of a licensed professional, Dr. Chen has over 30 years of experience and is certified by the state of Colorado. I have no reason to question his assessment. Patricia leaned forward. Mr. Ortiz, the issue here isn't just structural safety, it's about community appearance standards. Your property looked unsightly with that excessive snow accumulation. With all due respect, that's subjective. I documented at least 15 other properties in the development with comparable or greater snow accumulation. None of them received violation notices. Those properties were not brought to the board's attention. So the HOA is only enforcing rules against people that Patricia happens to notice or that someone complains about. That seems arbitrary and unfair. Patricia's face reddened again. Mind your tone, Mr. Ortiz. This board has the authority to determine violations as we see fit, based on community feedback and our own observations. But you're not applying the rules consistently. That's the definition of unfair enforcement. The woman sitting to Patricia's left, a thin blonde who looked to be in her 40s, cleared her throat. Mr. Ortiz, do you have evidence that these other properties had similar accumulation? I pulled out my photo documentation. Yes, here are photos I took on the day I received the violation notice, showing numerous other houses. I spread the photos on the table. The board members leaned in to look. I could see some uncertainty on their faces, but Patricia remained rigid. These photos don't show comparable accumulation, Patricia said flatly. Your snow drifts were clearly more excessive. That's not true. Look at this one, 1745 Meadowbrook. That drift is easily 6 feet high. We'll take this documentation under advisement, Patricia said, her tone making it clear that she planned to do no such thing. Is there anything else? Just that the snow has now melted naturally, exactly as Dr. Chen predicted it would. No damage occurred to my property, and had I paid for forced removal, I would have damaged my roof and spent nearly $1,000 unnecessarily. The HOA's violation notice was not only unfair, it actively encouraged me to damage my own property. Noted. You may sit down. The board will deliberate and provide a written decision within 10 business days. I returned to my seat, frustrated by the obvious hostility from Patricia, but hopeful that the other board members might be more reasonable. They called up 2 more appeals. One was from a homeowner who had received a violation for having a basketball hoop in their driveway. Another was from someone who had painted their front door a slightly different shade of approved colors. Both were denied within minutes of presentation, with Patricia leading the charge each time. After the formal meeting ended, I tried to approach the other board members, but Patricia intercepted me. "Mr. Ortiz, the board will review your appeal and provide a written decision. There's nothing more to discuss tonight. Can I at least speak with the other members? They have nothing to say to you right now. Please leave the community center." I drove home angry and discouraged. The whole process felt like a sham, a rubber stamp for Patricia's personal crusade against anyone who didn't bow to her authority. 10 business days later, I received the written decision. Appeal denied. The $500 fine stood, plus the $50 late fee since I had not paid within 30 days. I now had 15 days to pay $550 or face additional penalties. The decision letter was brief and unhelpful. It stated that the board had reviewed my appeal and determined that the original violation was valid, that aesthetic standards were part of community maintenance obligations, and that my engineer's report did not override the HOA's authority to enforce bylaws. I sat at my kitchen table, holding the letter, trying to decide what to do next. I could pay the fine and let Patricia win, or I could fight further. But fighting meant lawyers, and lawyers meant money I didn't have to spare. I called Tom again. They denied my appeal. Of course they did. Patricia runs that board like her personal fiefdom. What are you going to do? I'm not sure. Can they really force me to pay this? Technically, yes. But you could lawyer up. I bet if you threatened legal action, they might back down. Lawyers are expensive. So is letting the HOA push you around. This won't be the last time if you don't stand up to them now. Tom was right. I spent the weekend researching HOA law in Colorado and found a lawyer named David Kramer who specialized in homeowner association disputes. His website featured several case studies where he had successfully fought overreaching HOAs. Monday morning, I called his office. His paralegal scheduled me for a consultation that afternoon. The consultation fee was $150, but at this point, I was committed. David Kramer's office was in a modest building near the Pearl Street Mall in downtown Boulder. He was a slim man in his early 40s, wearing jeans and a button-down shirt, which made me immediately like him more than I would have liked some suit-wearing corporate type. We sat in his office and I walked him through the entire situation, showing him all my documentation. He took notes on a legal pad, occasionally asking clarifying questions. "This is actually a pretty strong case," he said when I finished. "The HOA's enforcement was clearly arbitrary. You have documentation of similar violations they ignored. You have a licensed professional's assessment that removal would cause damage. And most importantly, they're trying to fine you for something that resolved itself naturally without any harm. So what can we do? First, I'll send them a letter on legal letterhead explaining that you're represented by counsel and that we believe the fine was improperly assessed. Sometimes that's enough to make them back down. If not, we can file a lawsuit for declaratory relief and potentially for harassment and selective enforcement. How much will this cost? The letter is $300. If we have to file suit, we're looking at a retainer of $5,000, though costs could go higher depending on how hard they fight. However, if we win, we can seek attorney fees and costs. Colorado law allows for that in HOA disputes where the association acted in bad faith. $5,000. I felt my stomach drop, but then I thought about Patricia's smug face, about her casual threats against my property, about how she would keep doing this to me and other homeowners if someone didn't stand up to her. "Send the letter," I said. David smiled. "Good choice. I'll draft it today and send it certified mail tomorrow. We should have their response within a week or two." I wrote him a check for $300 and left feeling like I had finally taken real action. The letter went out Tuesday morning. By Friday afternoon, I received a phone call from David. "That was fast," he said. "I just got a call from the HOA's attorney, a guy named Stephen Walsh. He's with a firm that represents several HOAs in the area. He basically said the board stands by its decision and that you need to pay the fine." So now what? Now we file suit. I'll draft the complaint this weekend. We're going to argue selective enforcement, bad faith, and violation of your due process rights under the HOA's own bylaws. Get me that retainer and we'll get the ball rolling. I spent the weekend figuring out my finances. I had some savings, though not as much as I would have liked. $5,000 would hurt, but I could manage it. More importantly, this had become about principle. Patricia and her board couldn't be allowed to bully homeowners with impunity. Monday morning, I delivered the retainer check to David's office. He already had the complaint drafted. It was 20 pages of legal arguments and citations, much of which I didn't fully understand, but the core was clear. The HOA had abused its authority, enforced rules arbitrarily, and ignored professional assessments in favor of aesthetic preferences. We filed the lawsuit in Boulder County District Court on Tuesday. Under Colorado law, the HOA had to be served with the complaint. David arranged for a process server to deliver it to Summit Property Services. The response was swift and dramatic. Wednesday afternoon, I received an angry phone call from Patricia herself. "How dare you sue the HOA, Mr. Ortiz? This is outrageous and completely uncalled for. You denied my legitimate appeal and are trying to fine me for something that caused no actual harm. You are wasting HOA resources with this frivolous lawsuit. Those resources come from dues paid by your neighbors. You're stealing from them. I tried to resolve this reasonably. You gave me no choice. This isn't over, Mr. Ortiz, not by a long shot." She hung up. The venom in her voice was startling. This had clearly become personal for her. That evening, I found my trash cans tipped over in my driveway. Nothing was taken, they were just knocked over and the contents scattered. It could have been animals, but the timing seemed suspicious. Thursday, someone reported my car to the HOA for having an oil stain on the driveway. It was a tiny spot, barely visible, probably from when I had changed my oil 6 months ago. But suddenly, it was a violation requiring immediate remediation. Friday, I received a violation notice for having my house numbers mounted incorrectly. According to the notice, the numbers should be clearly visible from the street in approved metallic finish, and mine were apparently half an inch too small. This despite the fact that they had been there since before I bought the house. Patricia was retaliating. It was obvious and petty, but also potentially problematic. I documented everything and sent it all to David. "This is actually good for us," he said when I called him. "It shows a pattern of harassment. Keep documenting everything. Take photos, save all the notices, note the dates and times. If this keeps up, we can amend our complaint to include harassment claims." The lawsuit moved slowly, as lawsuits do. The HOA filed an answer denying all allegations. We entered discovery, which meant both sides had to exchange documents and information. David requested all HOA board meeting minutes for the past 2 years, all violation notices issued during that time, and all communications regarding my property. The HOA fought the discovery requests, claiming they were overly broad. There was a hearing in May before a judge, who ordered the HOA to produce most of the requested documents. I attended the hearing and saw Patricia sitting with the HOA's attorney, Stephen Walsh. She glared at me across the courtroom like I had personally wronged her. When the documents finally arrived in June, they were revealing. The HOA had issued violation notices to 97 properties over the past 2 years. However, the enforcement was wildly inconsistent. Some homes had been cited multiple times for minor issues, while others with obvious violations had never received notices. More interesting was the pattern David discovered. The homes that received the most violation notices tended to be owned by younger residents, minorities, or people who had opposed Patricia in some way. The homes that never received violations were owned by Patricia's friends and allies. "This is discrimination," David said during one of our meetings in July. "Not necessarily illegal discrimination based on protected classes, though there might be some of that, but definitely selective enforcement based on personal preference. This strengthens our case significantly." We also got the board meeting minutes, which showed that Patricia dominated every discussion. She railroaded decisions, shut down dissent, and basically ran the HOA as her personal kingdom. In several instances, board members had raised concerns about her aggressive enforcement tactics, but she had dismissed them. As summer progressed, the violations against me continued. In June, I was cited for having dandelions in my lawn. In July, for having my garage door open for more than 2 hours while I cleaned it out. In August, for having a package sit on my porch for 3 days while I was out of town for work. Each violation came with a fine. By September, the HOA claimed I owed them over $2,000 in various penalties. I paid none of them, instead adding each notice to our evidence file. In late September, the HOA escalated. I received a certified letter stating that, due to my unpaid fines, they were moving forward with placing a lien on my property. The letter came from their attorney and was filled with threatening legal language about foreclosure and collections. David immediately filed for a temporary restraining order to prevent the lien. We had a hearing in early October. This time, the hearing was more substantial. Both sides presented arguments. David laid out our case, showing the pattern of selective enforcement, the documentation of similar violations that were ignored on other properties, and the obvious retaliation against me for filing the lawsuit. The HOA's attorney argued that the board had broad discretion to enforce community standards, and that my refusal to pay legitimate fines justified the lien. Judge Sarah Martinez, a no-nonsense woman in her 50s, listened carefully to both sides. At the end of the hearing, she granted our temporary restraining order, preventing the HOA from placing a lien until our main case was resolved. "I have significant concerns about the enforcement patterns described by plaintiff's counsel," Judge Martinez said. "This matter needs to be fully litigated before any liens are placed." Patricia looked furious as we left the courtroom. I heard her arguing with Stephen Walsh in the hallway, her voice rising. He was trying to calm her down, but she was clearly beyond reason. The trial was scheduled for March of the following year, almost exactly 1 year after the original board meeting where my appeal was denied. In the meantime, David and I prepared our case. We identified other homeowners who had been victims of Patricia's selective enforcement and convinced 3 of them to provide declarations supporting our lawsuit. One was a young couple who had been repeatedly cited for trivial violations after they opposed Patricia's proposal to increase HOA dues. Another was a Hispanic family who had received 5 violation notices in a single month, all for questionable issues like excessive holiday decorations and unapproved lawn ornaments. The third was a retired veteran who had been fined for flying an American flag that was supposedly too large, even though the federal Freedom to Display the American Flag Act protected his right to do so. Winter came again, and ironically, we got another heavy snow season. This time, many houses developed significant snow accumulation. I watched with grim satisfaction as the drifts built up on houses throughout the neighborhood. I wondered if Patricia would issue violation notices to everyone, or if she would quietly ignore the situation. She ignored it. Not a single violation notice went out regarding snow accumulation, even on houses with drifts larger than mine had been the previous year. David had me document everything with photos and dates. "This is perfect," he said. "It shows that the snow issue was never really about safety or aesthetics. It was about targeting you specifically." As we moved into January and February, preparing for the March trial, I felt cautiously optimistic. We had a strong case, good evidence, and multiple witnesses. But I also knew that trials were unpredictable, and Patricia seemed like the type who would fight to the bitter end rather than admit she was wrong. In late February, something unexpected happened. I received a call from Tom, who had been following my case with great interest. "Owen, you need to hear this. I was at a neighborhood gathering last night, and someone mentioned that Patricia has been skimming money from the HOA reserves." "What? How?" "I don't know the details, but apparently one of the board members discovered some irregularities in the finances and confronted her. She dismissed it, but he's been digging deeper." "Who's the board member?" "Guy named Frank Morrison. He's the heavyset older man who was on the board during your appeal hearing." I immediately called David and told him what I had heard. He was intrigued. If there's financial impropriety, that's a much bigger deal than selective enforcement. Let me see if I can reach out to this Frank Morrison. David contacted Frank, who was initially reluctant to talk, but eventually agreed to meet. Frank came to David's office on a Saturday morning in early March, just 2 weeks before our trial. I was invited to attend. Frank was clearly nervous. He kept fidgeting with his coffee cup as he spoke. "I've been on the HOA board for 3 years, Frank said. "Patricia runs everything, and I mostly just rubber-stamped her decisions. But 6 months ago, I started noticing that our reserve fund balance seemed lower than it should be." "How much lower?" David asked. "We should have had about $80,000 in reserves, but when I finally got access to the actual bank statements last month, we only had $43,000. Where did the rest go? That's what I've been trying to figure out." I found evidence of several large payments to vendors that seem questionable. There was a $15,000 payment to a landscaping company for work that was never done. Another $10,000 to a legal services firm for work that our regular attorney says he didn't perform. "Do you have documentation?" "Some. Patricia controls most of the financial records through Summit Property Services, but I've been taking photos of documents when I can." Frank pulled out his phone and showed us images of bank statements, invoices, and payment authorizations. David examined them carefully. "This needs to be reported to the authorities," David said. "If Patricia has been embezzling HOA funds, that's criminal theft." "I know," Frank said quietly, "but I'm scared. Patricia is vindictive. Look what she's done to Owen. If I blow the whistle, she'll make my life hell." "She can't make your life hell if she's been removed from the board for embezzlement," I pointed out. "Frank, you have to do the right thing here. She's stealing from all of us." Frank wrestled with the decision for several minutes, staring at his coffee cup. Finally, he nodded. "Okay, what do I need to do?" David spent the next hour going through Frank's evidence and advising him on next steps. Frank needed to formally request a full financial audit through proper HOA procedures. He also needed to file a report with the Boulder Police Department. as the amounts involved crossed the threshold for felony theft. The following Monday, Frank submitted a formal request for an independent audit of HOA finances. He sent it to all board members and to Summit Property Services. He also went to the police station and filed a report, providing copies of the evidence he had gathered. Patricia's response was immediate and nuclear. She called an emergency board meeting for Wednesday evening and proposed removing Frank from the board for violating his fiduciary duty by making unfounded accusations. Frank contacted David, who advised him to attend the meeting with legal representation. David offered to accompany him. I also showed up, along with about 20 other homeowners who had heard rumors about financial irregularities and wanted to know what was happening. The community center was packed. Patricia sat at the board table looking thunderous. The other 3 board members looked uncomfortable. Frank sat with David in the front row. Patricia called the meeting to order and immediately moved to the removal resolution. This board needs to address Frank Morrison's reckless and defamatory accusations regarding HOA finances. His unfounded claims have damaged the reputation of this association and created unnecessary panic among residents. David stood up. Patricia, as Frank's attorney, I need to inform you that this meeting is procedurally improper. Under Colorado HOA law and your own bylaws, board members can only be removed by a vote of the membership, not by other board members. Sit down, sir. You are not a homeowner and have no standing to speak at this meeting. I'm speaking as legal counsel for a board member who is being unlawfully targeted. If you proceed with this removal attempt, we will seek an injunction. One of the other board members, the thin, blonde woman I remembered from my appeal hearing, spoke up. Patricia, I think we should table this until we consult with our attorney. This doesn't feel right. We don't need to table anything, Patricia snapped. Frank has violated his duties and needs to be removed immediately. Actually, I'd like to hear what evidence Frank has about these financial irregularities, the woman said. Her name was Linda, I later learned. I've never seen detailed financial reports, and as board members, we should have access to that information. The finances are fine, Linda. This is a distraction. Then there should be no problem with an independent audit, Linda said, her voice growing firmer. Patricia's face was bright red now. I will not dignify these baseless accusations by wasting HOA funds on an unnecessary audit. Frank stood up. The accusations aren't baseless, Patricia. I have bank statements showing that our reserve fund is $37,000 short. I have invoices for work that was never performed. I have payment authorizations that bypass proper board approval. The room erupted in angry murmurs. Homeowners started shouting questions. Patricia banged a gavel, but nobody paid attention. Everyone sit down and be quiet, Patricia yelled. This meeting is about board business, not wild conspiracy theories. If it's a conspiracy theory, prove it, someone shouted from the back. Let us see the bank statements. The meeting devolved into chaos. Patricia tried to maintain control, but the homeowners were angry and demanding answers. Finally, after 20 minutes of shouting, Linda made a motion to authorize an independent audit. One of the other board members, a quiet man named Robert, seconded it. We can't vote on that without proper notice, Patricia protested. Actually, under emergency provisions in the bylaws, we can, Linda said. Robert, how do you vote? I vote yes for the audit. I also vote yes, Linda said. That's 2 in favor, Patricia. This is absurd. I vote no. The other board member, a woman named Susan, looked torn. I think we need transparency. I vote yes. 3-1, the motion passes, Linda said. Patricia, you need to provide all financial records to the audit firm we select. Patricia stood up abruptly, her chair scraping loudly. "This board is out of control. I'm done with this circus." She stormed out of the community center, leaving the other board members and stunned homeowners behind. Over the next few weeks, things moved quickly. The independent audit firm, selected by Linda and the other board members, began their work. Patricia initially refused to cooperate, but when David threatened to seek a court order compelling her to produce records, Summit Property Services provided what they had. The audit findings were damning. Over a 3-year period, Patricia had systematically embezzled approximately $47,000 from HOA funds. She had created fake invoices from shell companies she controlled, authorized payments to herself for bogus consulting services, and simply written checks from the HOA account to her personal account, disguising them as legitimate expenses. The audit firm turned their findings over to the Boulder Police Department. In late March, just 3 days before our trial was scheduled to begin, 2 detectives showed up at Patricia's house and arrested her for felony theft and fraud. I watched from my front window as they led her out in handcuffs. She was screaming about persecution and unfair treatment, but the detectives were professionals and calmly put her in the back of their unmarked car. With Patricia facing criminal charges, the HOA's attorney, Stephen Walsh, contacted David to discuss settling our civil lawsuit. We met at David's office the following day. "Look, this whole situation has spiraled out of control," Stephen said. He looked tired and more than a little embarrassed. "The board, or what's left of it, wants to resolve this matter. They're willing to drop all fines against Mr. Ortiz, reimburse his legal fees, and issue a formal apology." "That's a start," David said, "but my client has been harassed for over a year. He wants more than just an apology." "What are you looking for?" David had prepared a settlement proposal. It included dropping all fines, reimbursement of my $5,000 retainer, plus David's additional fees that had accumulated beyond that, a formal written apology to be posted in the community newsletter, and a policy reform requiring the HOA to follow proper procedures and document enforcement decisions. Stephen reviewed the proposal. "The financial terms are fine. The policy reforms might be harder. The board would need to approve those." "Then get them approved," David said. "Otherwise, we go to trial, and I assure you, with everything that's come out about Patricia's conduct, my client will win. And when he wins, he'll be entitled to all his attorney fees, costs, and potentially punitive damages. We're being reasonable here." Stephen made some calls. Later that afternoon, he confirmed that the remaining board members agreed to all terms. We signed the settlement agreement the next day. I received a check for $7,300, covering my retainer and the additional fees. All fines were formally vacated. And the HOA agreed to implement new policies requiring documented justification for all violations, mandatory photographic evidence, and a clear appeals process with neutral oversight. The criminal case against Patricia moved forward. She hired an expensive defense attorney and tried to fight the charges, but the evidence was overwhelming. In June, facing the prospect of a trial she would almost certainly lose, she accepted a plea deal. She pleaded guilty to felony theft and was sentenced to 2 years in prison, though 18 months were suspended. She would serve 6 months in county jail, followed by 5 years of probation. She was also ordered to make full restitution of the $47,000 she had stolen. The Homeowners Association elected a new board in July. Linda became the new president, and she immediately set about reforming how the HOA operated. The new board was transparent, held regular meetings where homeowners could voice concerns, and enforced rules fairly and consistently. I actually ended up joining the board myself the following year. I figured that the best way to prevent another Patricia situation was to be actively involved in the governance of our community. It was sometimes tedious work, but it was also satisfying to help build something better. The snow on my roof had melted naturally that first winter, just as Dr. Chen had predicted. It caused no damage, required no expensive removal, and now served as a reminder of how a simple weather event had exposed a corrupt system that needed reform. I sometimes drove past Patricia's house, which had been foreclosed on when she couldn't make her mortgage payments after the restitution order. A young family bought it at auction. They were nice people with 2 small kids. I helped them move in and warned them about the HOA's history, though I assured them things were different now. Tom still lived next door, and we still had our morning coffee conversations. He liked to joke that I had gone from HOA victim to HOA reformer, which was true enough. The lawsuit had cost me time, stress, and some money, but it had also resulted in real change that benefited everyone in the community. The whole experience taught me something important about standing up to petty tyranny. People like Patricia thrive when others are too intimidated or too busy to fight back. She had gotten away with her abuses for years because most people just paid the fines and moved on. It took someone stubborn enough, or maybe foolish enough, to dig in and refuse to accept her arbitrary enforcement. I kept Dr. Chen's structural engineering report in a frame in my office, not because the technical details mattered anymore, but as a reminder that expert opinions matter, that documentation matters, and that sometimes the right answer is to stand your ground even when it would be easier to just comply. The final irony was that the following winter was mild. We barely got any snow accumulation at all. My roof remained clear all season without any intervention required. But if we ever did get another heavy snow year, I knew exactly what I would do. I would take photos, document conditions throughout the neighborhood, and if necessary, hire another structural engineer. The difference was that now, the HOA would actually listen to that expert opinion instead of ignoring it in favor of aesthetic preferences. Justice is not always swift, and standing up for what is right is not always easy. But sitting at my kitchen table on a quiet Saturday morning, watching light snow fall outside while I reviewed the reformed HOA bylaws that I had helped write, I felt a deep sense of satisfaction. Patricia was serving her jail sentence. The community had better governance and my roof was fine, just as it always had been. The whole saga had started with a simple orange violation notice slapped on my door on a February morning. It had spiraled into a year-long legal battle that exposed corruption and resulted in criminal charges. But it had also created positive change that would benefit homeowners for years to come. Sometimes, you fight not just for yourself, but for everyone who comes after you. And sometimes, refusing to pay an unjust fine for snow on your roof becomes about something much bigger than snow or roofs, or even homeowner associations. It becomes about accountability, fairness, and the principle that nobody should be allowed to abuse power just because they have a title and a clipboard. Patricia learned that lesson the hard way, in a county jail cell. The rest of us learned it too, in a better way, by building something better from the wreckage of her failed leadership. The snow melted. The trees bloomed. Life in Meadowbrook Heights moved on, improved and more just than before. And I slept soundly, knowing that my roof was structurally sound, my property was secure, and my community was finally governed by reason rather than the whims of one vindictive person who confused authority with entitlement.